statistics, timelines, and I will also share with you 4 recent dispute cases. So first up, next page, is the statistics. During early April and early May this year, there were 212 dispute cases lodged in the Fair Work Commission. 60% of it has been withdrawn, which means more than half of them did not really need to go that far. And the rest of it was mainly about whether or not a casual employee was eligible, or if an employer was eligible, or whether or not the one-in, all-in principle applied correctly. That is, the employer cannot pick and choose an eligible employee. If you nominate one, all eligible employees have to all be included. This is the one-in, all-in principle. Stand-down cases that started before the 9th of April, which was when the Fair Work JobKeeper provisions started. The employment status of employees were also a common dispute. And the last common nature of dispute were cases where dismissed employees try to seek re-engagement to become eligible. For example, employees who have been given directions or become disqualified by unavoidable circumstances. On top of JobKeeper disputes themselves, there are unfair dismissal claims as well that increased by 60% in April this year compared to the same month last year. So if you wondered, with the additional number of cases, how long would a case take to resolve? Well, the Fair Work Commissioner aims to conclude a case within 2 weeks from its lodgement. But broadly speaking, the Fair Work Commission really aligned with employer, paying greater weight to the interest of job security in preserving of employment as opposed to other conditions of a consideration. Though in some cases, such as cases of fair and reasonableness, that it must take into account in a significant way the statutory, the award, agreement, and contractual entitlements of impacted employee. An example of this case is a couple of weeks ago where a settled case was challenged. So this case actually settled before, but eventually overturned by the challenge. So this was between the TWU and Cruiser Australia, which was a bond transport company for cash and valuable transportation. The business structure has been impacted, and they applied a reduction in hours of work down to 15 to 20 hours per week per employee, which at the time it went to the Fair Work Commission and was held as reasonable in that circumstances. After that, this case was appealed, and with overturned the direction of the assessment that applied in the first place was incorrect. Hence, the previous assessment was void. On this appeal, the focus point was on the fact that the direction impacted greater on the full-time employees than others group. So the full bench and the Fair Work Commission said the consideration should also be given to whether or not the proposed direction disproportionately and unfairly affects one category of employee over another. The full bench also held that the employer cannot be reasonably expected to prepare a system which reduces all employees' hours of work in equal proportions. So that means they don't expect you to have like exactly perfect number of hours for every single employee. So they don't expect that, but as long as you are reasonable. So now they were suggested to go back to work on a new direction with the correct considerations. And if they can't, they could come back for the direction from the Fair Work Commission, so they can give one to them. The next case is quite a simple case, but nonetheless, it's a good example for people to hear, I think. It's a case between La Plume and Thomas Foods International. So there was a downturn on work due to supply chains, which was caused by COVID-19. A clerk at their head office was stood down without pay under the Section 524 for more than 5 weeks. Although the work in the head office continued, but in a reduced manner. Because that was not a stoppage of work, but only a reduction, the Fair Work Commission ordered for a back payment to that clerk, but only partial. That was calculated with the correct application of the hours reduction, if it was to calculate properly for her. So the Fair Work Commission noted that fairness cuts both ways. So while the clerk actually got some payment back, it wasn't full because part of it was also entitled for the company as well. So now the last 2 cases, both of these last 2 cases were on redundancy payout adjustment. So listen carefully, so you may be able to make some use of some of these examples. So the first one is with the company called Hyperlife, and with their 4 employees involved. Their circumstances were that they were in a position of not being able to pay the full redundancy entitlements to these 4 employees. At that point in time, they had about $38,000 in cash, which was to be used to pay other staff wages in the very following week. They presented a letter from their accountant confirming their position of assets and liabilities, which are pretty much on par. The company had also received a number of loans from family and company's director. Unfortunately, this company was not receiving JobKeeper help because they happened to acquire another business last year that made them not entitled for the JobKeeper help. But together with clear supporting documentation and traceable evidence, as well as other considerations by the Fair Work Commissions, such as the ability to preserve the operation of the company and for the rest of the employees to be able to continue being employed, the Fair Work Commission ruled that the redundancy reduction application was granted. On the other hand, with the next case, for the company called Coal River Farm, they will also apply for a reduction on a redundancy payout on 2 employees. That was on the ground of their 100% loss of their revenue that was impacted by COVID-19. The other 22 employees were solely on JobKeeper. The company had some limited funds in the bank for cash flow purposes, but they also had some significant liabilities, including a debt to the ATO. But they provide a range of financial documentations, but the Fair Work Commission was not able to find a clear evidence from those documents to conclude that they were unable to afford the redundancy payout. So there were unclear screenshots, there were undefined bills, they were unable to provide clear evidence or proof of their financial status before COVID-19. So there were a few things that they were not being clear. For that reason, the Coal River Farm's application was not successful due to the unclear financial evidence to support that case. The two involved employees obtained their full redundancy entitlement in the end. So with these 2 cases, it shows that clear and complied record keeping is very important, particularly when you need them in difficult times. Thank you for your attention, and I hand this back to Helen.
Thank you, Maddie. Really appreciate it. That's very useful. I think some of the business out there, when they are struggling or experiencing or about to settle the employee exit from the business, they should consider if they are eligible to apply for